Welcome to this third video in our series about unitary patents and the Unified Patent Court, the UPC. There is still a large number of unknown circumstances and factors in the performance of the UPC. It is also unknown whether there will be differences between local or regional divisions, whether some will be more or less pro-owner or pro-infringer than others. In any case, and as we have seen already, there is the possibility of choosing the forum according to one's own interests or calculations. And this can also be a double-edged sword that, as we have also already mentioned, would have an effect not only on unitary patents, but also on classic patents, both those already granted, even those already expired, and those to be granted in the future. This last part, the jurisdiction in respect of classic or traditional, that is, non-unitary patents, both existing and future, we have already mentioned that it is subject to transitional provisions. Let us see what they are. The transitional period to which we are going to refer is 7 years from the entry into force of the UPC. This first 7-year period could be extended again for another 7 years. During this transitional period, and for non-unitary European patents, the jurisdictions of the UPC will not be exclusive, but will be shared with the corresponding national courts. Thus, infringement or revocation proceedings related to classic or traditional patents, as well as their corresponding SPCs, may also be brought before national courts, provided that no action has been brought before the UPC. In addition, proceedings pending before a national court after the end of this transitional period would continue in such national court without reverting to the UPC. As mentioned before, judgments of the UPC will apply in all member countries that have ratified its participation. This implies that a single action will have effect in a large number of jurisdictions. Nevertheless, during this transitional period of shared jurisdiction between the national courts and the UPC, a provision has been made for the possibility of being able to remove non-unitary patents, and I insist, their corresponding SPCs, from the jurisdiction of the UPC. This will be possible as long as no action has been initiated before the UPC. This is what is known as opt-out, the option to remove non-unitary European patents from the jurisdiction of the UPC, so that legal actions can only be brought in national courts. This opt-out can be done at any time during the transitional period, provided, I insist, that no action has been initiated before the UPC. In fact, classic patents may be taken out of the system also during a period prior to the start of operation of the Unified Court, the so-called sunrise period. This will prevent a classic patent from being blocked under the jurisdiction of the UPC if someone files a lawsuit on the first day the UPC agreement enters into force. This sunrise period will start 3 months before the entry into force of the UPC. The foreseen day, as of today, is the 1st of January 2023. It should also be noted that an opt-out may be cancelled as long as no litigation has been initiated in a national court. In other words, the opt-out is a reversible process, so that it will be possible to reintroduce a classic patent within the jurisdiction of the Unified Court at any time. This is known as an opt-in. Additionally, 2 transitional measures have been introduced by the EPO, the European Patent Office, in order to allow an early uptake of the unitary patent by users whose European patent applications are about to be granted. After January 1st, and before the entry into force of the system, if the usual grant timing does not allow to request a unitary patent, the applicant could use one of these 2 options. File an early request for unitary patent. This request will be granted if the applicant has received the notification of the intention to grant, the communication under Rule 71.3, and the request has been filed within the sunrise period. Or file a request to delay the grant of the European patent. If the grant has not been approved by the applicant yet, and the request has been filed within the sunrise period, the EPO will delay the grant until after the system has entered into force. So, we come to the last part of this series. What should we do? How do we prepare for the imminent arrival of the new system? The answer includes reviewing our portfolio and our situation, evaluating the different possibilities we have, and deciding on the strategies we are going to follow, both for our existing patent portfolio and for possible future ones. The issue to consider and decisions to make are multiple. For example, what will be our validation strategy and our preference on jurisdiction for both existing and future portfolio? Are we interested in a diverse mix of classical European patents, unitary patents, utility models, and national patents? And if so, which ones? How are we going to organize them? Similarly, we must define the strategy with respect to exit and re-entry options, that is, opt-out and opt-in for all or part of our portfolio, both current and future. In order to decide this, we will undoubtedly have to consider questions such as: what is the value of the technology in each patent family and in each jurisdiction? Are there or not interactions between several patents or patent families in order to protect certain commercial products? What is the likelihood of revocation actions against certain patents in my portfolio? Who should we take into consideration to decide on the appropriateness of such opt-outs and opt-ins? That is, who has rights or owns or co-owns those rights? We will also need to review existing and future licensing agreements for Europe and make sure that they are all aligned with the new system. Notice that exclusive licensees would, in principle, be able to bring actions to the UPC without the licensor's consent, unless the license specifies otherwise. Similarly, non-exclusive licensees would not be able to bring such actions unless the license agreement specifies otherwise. Once these questions have been analyzed, we should also think about other issues of a more symbolic or image-related nature, but which are nonetheless, at least potentially, important. For example, we could consider whether or not we should evaluate the message and the signals that our actions may send to the market and to our competitors. If we decide to minimize risks and therefore take all or part of our portfolio out of the system, which is a very valid decision, could we be projecting a position of distrust in the strength of our patents? Should we take advantage of the situation to monitor our competitors' strategy in terms of their own opt-outs and opt-ins? Is it in our interest, or can we afford, to contribute to the implementation and participate in the creation of case law and experience of the new system? In closing, I would like to issue a wake-up call. We must be aware that the assessment and adoption of strategic decisions does not complete the process. After their review and evaluation, all these decisions will have to be implemented. Let us remember that such implementation involves a complicated administrative part. For example, any opt-out will have to be agreed upon with all the owners of the right. This is not the same as the registered owners. It may be necessary to check the ownership of each of these rights, even if it's not necessary to correct the records. Let us also remember that the opt-out is effective in all jurisdictions, even in those where participation in the system has not yet been ratified. It is therefore of paramount importance that we contact, agree, and obtain all the necessary authorizations. The complication, and therefore the time and resources that we will have to dedicate to it, will grow proportionally to the size of the portfolio. We should also bear in mind that there will be an additional layer of complication in cases where patents have been licensed. It is therefore vitally important to start the decision-making process. The earlier, the better. Not doing so, that is, not making a conscious decision as to how to act in the new situation, is in itself a decision to remain in the system with the default conditions. This brings us to the end of this seminar. We hope that it has been of interest to you and that we have been able to shed some light on this new system of the Unitary Patent and the Unified Patent Court. At Hungria, we remain at your entire disposal for all your needs in this regard. Likewise, we will be pleased to advise you and clarify any remaining doubts. For any questions, please contact our office or let us know directly through our email address, which is shown on the screen. Thank you very much for your attention. We hope to see you soon.